In today's lecture of e-commerce, we will study about the legal issues in e-commerce. And the topics we will cover about the Uniform Commercial Code for e-commerce, which includes the Model Law on Electronic Commerce by the United Nations Commission on International Trade Law, and the IT Act 2000 by Government of India. The Uniform Commercial Code for e-commerce, Model Law of Electronic Commerce includes United Nations Commission on International Trade Law Model Law on E-commerce. The Act facilitates e-commerce and e-governance in the country. The Act also establishes a regulatory framework and lays down punishment regimes for different cybercrimes and offences. Why these laws were made? If we want e-commerce across the countries, every country has its own law, so we must follow the law of that country, and there must be some uh, model law so that the every country can accept all types of e-commerce laws in their companies and to punish those people who are in the cyber crimes and who do some offenses in the e-commerce. So the general principles on which the model law is used is based to facilitate electronic commerce among and within nations, inside the nations and across the nations, to validate transactions entered into by means of new information technology, to promote and encourage the implementation of new information technologies, to promote the uniformity of law and to promote commercial practice. So these are the general principles on which the model law is based. Objectives of the model law. The purpose of the model law is to offer national legislators a set of internationally acceptable rules as to how a number of legal obstacles may be removed and how a more secure legal environment may be created for electronic commerce. The objectives of the model law, which include enabling or facilitating the use of electronic commerce and providing equal treatment to users of paper-based documentation and to users of computer-based information, are essentially for fostering economy and efficiency in international trade. UNCITRAL intends to continue monitoring and technical, legal and commercial developments and underline the model law. It might decide to add new model provisions to the model law or modify the existing ones. The model law applies to all kinds of data messages that might be generated, stored and communicated. The core provisions of the UN Citral Model Law is Article 5, that is legal recognition. Information shall not be denied legal effect, validity or enforceability solely because it is in the form of a data message or it is incorporated by reference. Article number 6, writing. Where the law requires information to be in writing, that requirement is met by a data message if the information contained therein is accessible so as to be useful for subsequent reference. Article 7 is signature. Legal requirement is met in relation to a data message if a method is used to identify the signatory and to indicate his approval of the information contained in the data message, and that that, that method is as reliable as was appropriate for the purpose for which the data message was generated or communicated. That is the article 7. The next article is 8, that is original. Legal requirement is met by a data message if There exists a reliable assurance as to the integrity of the information from the time when it was first generated in its final form as a data message or otherwise, and information is capable of being displayed to the person to whom it is to be presented. Article 9 Evidence. In any legal proceedings, nothing in the rules of evidence shall apply so as to deny the admissibility of a data message in evidence solely because it is a data message. IT Act 2000 by Government of India says objectives of the IT Act is to provide legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, commonly referred to as electronic commerce, which involves the use of alternatives of paper-based methods of communication and storage of information. To the second point is to facilitate electronic filing of documents with the government agencies. The Act came into effect on 17th of October 2000. These were the main purpose of the objectives of the IT Act, and these objectives were based on the model law of the UN. So what does IDEA 2000 legislation deals with? The Act essentially deals with the following issues like legal recognition of electronic documents, legal recognition of digital signatures, offences and contraventions, justice dispensation systems for cybercrimes. Then IT Act 2000 is applicable on following services. So number one is telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafes. The IT Act 2000 by Government of India. Major provisions of the IT Act are electronic contracts will be legally valid, legal recognition of digital signatures to be affected by use of asymmetric crypto system and hash function, security procedure for electronic records and digital signature, appointment of certifying authorities and controller of certifying authorities, including recognition of foreign certifying authorities, then controller to act as repository of all digital signature certificates, certifying authorities to get license to issue digital signature certificates, various types of computer crimes defined and stringent penalties provided under the Act, appointment of adjudicating officer for holding inquiries under the Act, establishment of cyber appellate tribunal under the Act, appeal from order of adjudicating officer to cyber appellate tribunal and not to any civil court. So all these are the major provisions of the IT Act which needs to be followed for the e-commerce websites. These are the references, and in the next lecture, we will cover the topic of intellectual property protection, that is copyrights, patents, trademarks, and domain names. Well then, thank you.